So she can't say, well, he said this or he did that. If you send a message that says the kid has a doctor's appointment or soccer or whatever it is, it's there, can't be deleted, can't be changed. So it's really a good protection for both of you to use. You can talk to Mr. Paget more about that.
May I speak?
Sure.
Go ahead.
I have this ankle monitor on. Is there any way I can get this off? I've been on it for about 7 months.
So that was a condition of your bond, and I don't know, do you have any issues?
I don't see anything
That's happened since then?
that would indicate.
He has been very diligent with it, and I don't think there are any violations, but it's been a great financial burden on him, and he's with one which he's managed to get done.
What's the status of the Hardin County?
We have court on the 20th, and I've spoke to the prosecutor there, and we're going to be running something concurrent with your case here, Your Honor.
Give me just a second.
Absolutely.
They also, there's another, it's called a Talking Parents co-parenting app. I don't care which app you use. If there's a new, better one, it's been a long time since I've used Family Wizard, but it will be through an online application, some type of app on your phone that y'all have communication about your child. You'll also be required to follow any and all rules if you get a probation in Hardin County with regard to contacting communication. Do you understand? Are you required out of Hardin County on that bond? Have they required you to have that GPS monitoring device?
No, Your Honor.
No, it's
They
just
have
here.
not.
Okay, so it was a condition of your bond here. It's not a condition of your probation. So as of today, you'll be able to get that taken off. So here's the thing, if you have any communication or contact that you're not supposed to have, not only will you be in trouble here, you're gonna be in trouble over there. You're looking here at going to prison for between 2 years and up to 10 years, just for having the wrong kind of communication. It's that simple. So she cannot give you permission to violate this order. So she may say, you know what, it's been a while, everything's fine, let's meet, let's do whatever, let's talk. You can't do it. Only I can give you permission to have any other communication other than about your child, other than through an app.
Yes.
Makes sense? If you do everything you're supposed to, get past the situation, and successfully complete your probation, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation, the case will actually be dismissed. You'll never have a felony conviction. But the other side of that is if you violate any condition, you'll be back in here again and looking at going to prison for 2 to 10 years. Do you understand?
Yes.
I'm handing you the trial court certification and it shows this was an agreement that I followed. And so you've waived any right to appeal. You'll just have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. All right. Good luck to you, sir. Thank you.
Thank you, Your Honor.
Thank you. Oh, thank you. Mr. Paget, you have another sentencing on a Daniel Martinez. Morning, are you Darius Jack?
Yes, ma'am.
And this is 25 DCCR 1624. Mr. Jack was previously in court, entered a plea of guilty to violating a protective order 2 or more times. And I have received the pre-sentence report. If you both had an opportunity to review that report.
Yes, Your Honor, I have
Any additions or corrections?
None, Your Honor.
nothing from the state judge.
All right, then, Mr. Jack, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That includes obviously having no contact with the victim in the case. And I understand that you guys have a child together. So it's very important that you get with Mr. Paget or someone to make sure that you have some legal documents in place for visitation and things like that. I will allow you to have contact or communication with her only through what's called the Family Wizard. It's an app that y'all can get on your phone. I will require you to pay the cost of that app. for you and her. That's how you will communicate about your child, unless y'all have a family member or someone else that you can go through. The good thing about that app, though, it's really designed to protect both of you, not just her, but you too, because everything you do is saved on that app. Good morning. Are you Daniel Martinez?
Yes.
And this is 25 DCCR 1414. Mr. Martinez was previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. I received the pre-sentence report, and has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections,
None.
explanations about self-defense?
There are situations that he'll tell you about, Your Honor, that he asked to speak about.
So here's the thing, Mr. Martinez, in your pre-sentence report, you didn't really accept responsibility. You said that you did this, but that you did it only in self-defense. If you did something in self-defense only, then
Listen to her first.
Yes, ma'am.
obviously that's a defense and you should go to trial.
Yes.
But if you did it and you're taking responsibility, then I need to know that.
No, look about that responsibility. And I said that to the probation officer.
Okay,
He probably took it a little bit wrong.
okay, all right.
Yes.
Any reason not to go forward then with sentencing, Mr. Smith? All right, then at this time, Mr. Martinez, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office. Defer all proceedings, place you on probation for 6 years. You're ordered to pay the $1,000 fine and to follow all the rules and conditions of probation. One of those is going to be that you are not allowed to have any drug or alcohol. And I am, at least for some amount of time, going to order that you wear a SCRAM unit, which is a unit that will tell me immediately if you have any alcohol in your system. Probation can tell you where you need to get that, but you need to get it, give them proof of it. Mr. Paget can explain that as well. Everything in here looks like alcohol had a huge part of it. The substance abuse evaluation that they did tells me that alcohol is an issue. If there is anything else that probation feels like would be helpful to make sure that you stay clean and some type of program, then you're going to be ordered to do whatever it is. Do you understand? If you do everything you're supposed to on this probation, this is an excellent opportunity because you do not have a felony conviction on your record. The end of the probation period, if you're successful, the case will actually be dismissed. You'll never have a felony conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, so you would be a convicted felon, and you could go to prison for anywhere in the range of punishment, which is between 2 years and up to 20 years in prison. Do you understand?
Yes.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. And if you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork. Yes, sir?
Yes, ma'am. I have a SCRAM device. I've been wearing it for 10 months.
Okay.
I have a GPS monitor that I've been wearing for 10 months.
So the GPS was a part of your bond. That's off. You can get that off today. The SCRAM until, if you'll just make a note that if they feel like that's the length of time is enough on probation, then they'll send me something over. But for now, let's keep that on.
So,
I know it's a lot of money. You can take the GPS though, you're done with that because that hadn't had any issues. And as long as they double check on that SCRAM, then I'm okay with that as well. Just.
And Your Honor, if he does his submission, if he shows that he's staying clean, there are no violations on it.
No, they'll take a look at how long you've had it on once you get with your probation officer, and it shouldn't be much longer. They'll send me something. We can get that.
Thank you very much.
Okay, thank you, sir.
Yeah, this is, explain this to you. You sound.
See, Mr. Radford, you've got Marquise Berry. Good morning. Are you Marquise Berry? And this is 25 DCCR 0882. Ms. Berry is set for trial for next Monday to begin with jury selection. And what is the announcement?
We're ready, Judge.
I think it's ready, Judge.
Okay. Any changes in any type of negotiations or that we need to talk about?
No, ma'am.
Looks like there was a rejection done a few months ago that was for a 10-year term in prison. That's still the offer.
Yes, sir.
All right, then, Ms. Berry, I'm going to number the cases for trial tomorrow after the docket. So stay in touch with Mr. Radford. He'll know tomorrow what the trial order is. But I anticipate seeing you back next Monday at 1 o'clock, okay? All right, you're free to go. We reset, Locker Fury. It's kind of bumped through.
I know, take that.
Oh, I see. Let's see.
But I-
Mr. Smith, what's the status of the federal Locker Fury stuff? Still waiting.
Scott about that. I emailed Ray, still haven't heard back. No change. The last time I talked to him, he said that the FBI is taking it from him and what they're supposed to be doing.
Ms. Lockhart Fury, I'm gonna reset your case one more time. Stay in touch with Mr. Rennick. We'll let him know if y'all want to send him a message. And make a note for me. I'm gonna get with Ray again on that, Moran. I'll see if I can find something out.
Scott said it. He's gonna be here.
Yeah, but if we're just resetting it, I mean.
Yes, ma'am.
Next week's trial don't get Cal. Mr. Reynolds, you've got John Taylor. Mr. Smith on John Taylor. Good morning, sir. Are you John Taylor?
Yes, ma'am.
And this is cause number 25 DCCR 1427. And it looks like Mr. Reynolds has filed a motion to withdraw as attorney. Is that correct?
Yes, ma'am. I've gone over that with him.
All right. Do you have any objection to that, sir?
No, ma'am.
So I'll grant that motion. And Mr. Taylor, are you able to hire another attorney?
Yes, ma'am.
So what I'll do, Mr. Taylor, is reset your case for about 30 days, and we're going to put you back on that designation docket. If you get a lawyer hired, I'm going to get you to sign a reset today so that you can bring that to that lawyer. If you are unable to hire someone before the next court date, make sure you talk to at least 3 attorneys. Bring me those names so I know you're trying, and we'll discuss your options, okay?
Yes, ma'am.
All right, if you'll step in front of the clerk, she'll give you that reset notice. Mr. Eckhart, you've got Bobby Clark. Hmm. Morning, Ms. French. Morning. Good morning, sir. You're Bobby Clark. And this is clause number 25 DCCR 0802. Mr. Clark is set for trial to begin with jury selection next Monday. And what is the announcement?
So Judge, we can be ready if we're put in the order. However, I think you know that I've spent most of my last month working on that case with Philip that was supposed to be on this docket. It was originally on this docket. So I haven't really done a lot of preparation on this case, but we can be ready if we're put in the order.
Okay.
And then also I'm tentatively not available on Thursday and Friday next week.
Okay.
If I have to, I'll cancel.
Okay. Ms. French?
Well, the state relied on Mr. Eckert's.
I did. So about a month ago, I did tell Judge that we were getting ready on this capital case and that I wasn't planning on trying this case.
Because it's so new as well.
Here's the thing, y'all don't get to pick which cases get numbered first or second. And I understand that capital was obviously a big one, but when we've got a child case, it takes precedence anyway. So that's you guys relying on each other. You should not do that. You should rely on me for that. I'll take that into consideration when I'm numbering the cases, but in future, make sure you loop me into that and don't assume that certain things are gonna happen with the trial docket, okay? Stay in touch with, Mr. Eckhart. He'll know tomorrow, by noon, or a little after that, what the trial order is for next week, and, he'll let you know when you need to be back next week, okay? All right.
Anyway, I'm just saying it out loud.
Yeah. Okay, Ms. French, on Brian Mitchell, Mr. Burbank is not going to be here this week. He is in trial in Orange this week and anticipates that to go into next week. Is that right on that one? I think he filed a motion for a continuance. What I'm going to do is double check with, to make sure that they did in fact begin that trial this week before I do any type of reset on it.
Okay.
If for some reason that one fell through today for him, is the state ready on Brian Mitchell?
We'll do what we need to do.
Okay, all right, so I will let you know as soon as I find out, today about it.
I think.
The other one, was that an email that had all of that lengthy stuff on it about? Proceedings? Mr. Gilthorpe, you've got Marco Morales. Morning.
Good morning.
Morning, Ms. Malvina. And sir, you Marco Morales? And this is 26 DCCR 0160. Mr. Morales is charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
Judge, we've received an offer, a new offer, and we're asking for a reset so we can check on the immigration effects of that offer.
Okay.
But I believe this will be a fleet case.
Okay, I'll reset it one more time. Looks like you were hired early March, so this will be the last reset. Make sure you stay in touch with Mr. Gilthorpe, so that you guys can visit about everything before that next court date and have a plan for that date, okay? All right, thank you. You're free to go, sir. Mr. Jeffries, you've got Artist McCoy. Mr. McCoy, have a seat in the jury box. I'm gonna get you tested this morning.
Hang on.
Yes, sir.
Run to the court.
Sure.
Next one.
This is what, you know, our junior.
Yeah. Mr. Nichols. Oh. Mr. Nichols, on, David Hatcher with Mr. Gertz, do we have the defendant here or we were not? Gonna have?
Says defendant.
He's got a couple of, did he file a motion though?
Yes, ma'am.
Filed a motion
And you
for
asked.
continuance on that, and I got a little more information about why. I'll let you read this. What is your position?
On that case, Judge, I think we're gonna have a solution. That I was hoping to talk to him about today, but if it needs to be reset for whatever, that's fine.
Okay, but you think there may be something that can,
I'll talk to him, next chance I get and see if we can move it up to deal with it.
if you can get with him this week, that'd be great. One second, why is this?
Do you have a copy of that motion?
Yeah. And then this is what? That just helps explain. Cause I'd like, if you guys get something worked out, I'd like to get that taken care of Monday morning next week. If
Okay.
there's a resolution, if you can, visit with him that week about that, and we'll send him, if you'll send him a message also, Kelly, to get with Mr. Nichols ASAP, so that if there's something that can get worked out, I want that taken care of Monday morning.
Okay.
If that makes sense.
Sorry.
For you. Just- All right, so just let me know if you can get with him this afternoon or tomorrow. Thank you very much.
Thank you.
Mr. Kelly,
He's back with his client.
thank you. Mr. Lewis, you've got Broderick Guillory. It's a sentencing.
Yes.
Judge, I'm signing paperwork on Mr. Kelly's case, so.
Thank you. Amos Molfino on Broderick Kelly. Good morning, sir. You Broderick Kelly?
Roger Gilbert.
Guillory, I'm sorry.
That's what I.
I don't know why I was saying Kelly, I guess because I just called Mr. Kelly's case. You're Broderick Guillory. Sorry, Ms. Molfino. No wonder you couldn't find that file. It's a sentencing. Yes, ma'am. That's because you know how to read my mind. Everybody else doesn't apparently. All right, Mr. Guillory was previously in court in cause number 25 DCCR 1716. Entered a plea of guilty to the state jail felony offense of burglary of a building. I've received that pre-sentence report. Have you both had an opportunity to review the report?
I have, Judge. There is something that we definitely want to address, and I've spoken with Mr. Gilbert about it. He would like to address it for Judge to.
Okay,
speak on it.
go ahead.
Yeah, I was, in the paperwork, I was a little nervous talking to the,
Speak up.
I was a little nervous talking to the woman about probation,
Yep.
and I basically wanted to say that I did what I was guilty for.
Okay, so it gives me concern, Mr. Guillory, that you come in, plead guilty, and then you go say, well, I didn't really do it. Somebody else did it. Accepting responsibility is sometimes hard, but it's something that you do, especially as an adult and when you've done something like this. So if you didn't do this, someone else took your truck, did all those things, then we'll have a jury come in and they can decide. If you did it, then just accept the responsibility because things will go a whole lot more smoothly between now and the end of this probation, hopefully. Does that make sense? All right, anything, Ms. Molfino, other than that? All right, then, Mr. Guillory, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney. Defer all proceedings, place you on probation for 3 years. You're ordered to pay a $500 fine. You're also ordered to pay restitution in the amount of $4,600 and to follow all of the other rules and conditions of probation. If you do that, this is a great opportunity. You don't have a felony conviction on your record. And at the end of the probation, if you successfully complete it, you'll never be a convicted felon. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you would be a convicted felon, and you could go to the state jail prison for between 6 months and up to 2 years. Do you understand? $4,600 is a lot of money to pay back. And a lot of people will think when they have restitution, I've got 3 years to do it. I'm going to wait, I'm going to sell something, or I'll wait till I get my tax refund or something like that. I want you to make payments on that every single month. Even if it's a little bit, it'll add up. Because what can happen is if you don't make payments on it, we can get to the end of your probation. You could have done everything else right. And if I find that you could have paid that restitution and you didn't, then you could still go to prison and be convicted, even though you've done everything else right but pay that money. It's very important that that gets paid back. And if you'll just make sure, I want at least half of that, anything he pays going to that. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go to your paperwork. All right, good luck to you, sir. Thank you.
Thank you.
You've got Michael Thomas, Mr. Lewis.
Yes.
Good morning, sir. You're Michael Thomas Jr. And this is 23 DCCR 0530. Mr. Thomas is set for trial with jury selection Monday. And what is the announcement?
Ready.
Okay, good. All right. So, Mr. Thomas, has there been any change in any kind of negotiations or anything like that? So it's very likely that your case is going to be at the top of the list. It's obviously very old, need to get it taken care of. Stay in touch with Mr. Lewis. He will know that trial order tomorrow, right after lunch, probably. But I anticipate seeing you next Monday at 1 o'clock. Okay. All right. See you then. And then you have a Charles Toussaint, Mr. Lewis.
Yes, ma'am. Yeah, he's outside of the wheelchair jail.
Okay, go get him.
Yeah. The nurse who was to sit for the sit in and put it all together. I may have that.
Good morning. You're Charles Toussaint.
Yes, ma'am.
And this is cause number 26 DCCR 0527. And what is the announcement?
Judge, there's some additional medical records I'm waiting on. I was able to, Mr. Tucson, I was able to talk to the nurse this morning. They're compiling that together, the rest of it that I need. So hopefully I may have it today.
Okay.
But I can just have one more setting. So I can review.
All right. Any issue, Mr. Smith? So, Mr. Toussaint, I'm just going to do a normal reset. That's about 30 days to give you some time to get everything you need to Mr. Lewis so he can get it to Mr. Smith. They can talk about it and then you guys can visit, see what your options are, and we'll get that figured out at the next court date.
Thank you.
All right. You're free to go. Thank
Thanks,
you.
Judge. Thanks.
Mr. Rojas, you got Tyler Douglas.
He's here, Judge. Call his name on one.
Morning.
Morning. I've actually never had any contact with me. Number I have is no good.
Okay. His bond will be forfeited for non-appearance and reset at 100,000. Let's see, Scott Howe, looks like I've got a dismissal
Yes,
in Mr. Howe.
he's been in treatment for
Yes.
7, 8, 9 years now, so we want to.
Perfect. All right, good luck, Mr. Howell. Take care. You're free to go, sir. And then Charleston A. Verdine to sentencing. This is Ms. Malvina. Oh, sorry. You were already walking it. Thank you, Mr. Nichols. Good morning. Are you Charleston A. Verdine? And Ms. Verdine was previously in court and entered pleas of true to counts 1, 2, 3, 4, and 5, and a motion to revoke her probation, is on probation for obstruction or retaliation. It looks like there was an agreement, but we got a updated pre-sentence report. Is that correct?
Yes, just to make sure you were.
Okay. You both had an opportunity to review that.
We have, Your Honor.
Yes.
Any other additions or corrections to that report?
No, Your Honor.
And I see probation's here. Is there any other thing you would need to add as far as what the recommendation is in that report? Okay, thank you, ma'am. All right, so Ms. Birdie, it looks like everybody here is willing to give you an opportunity to try to be successful on this probation. And so what I'm going to do is find that you previously entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do that. I'm going to follow the recommendation. Continue you on probation. I'm going to extend your probation for 2 years. So it'll be extended for 2 more years. You're ordered to enter and successfully complete the JCDI program, which is a drug program. It's outpatient, but you have to get through that whole program and the aftercare and everything. And if you do all of that, that should hopefully have you on the right track to being able to be successful and getting this probation over with and not having the conviction. Here's the other side to all of that. Now that you've already had a motion to revoke your probation, if you end up back in here on another motion to revoke, things will probably not go this smoothly. Do you understand? All right, so I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Do you need to talk to her before she leaves today? Make sure you stay and visit with your probation officer before you leave today, okay? All right. Yes, ma'am.
Since I'm gonna be on the JDCR program, can I get the jail tax?
That'll probably be part of that program. It's up to them at this point. I had it on as a bond condition, but a lot of times they will require it. It's gonna be up to them. I'll let them make that decision. Okay? Thank you.
Okay.
Yes, sir. Ms. Holmes, you've got Janaea Fine. It's a sentencing in 2 cases. Good morning. I'm gonna have the blood tested first. Good morning. You're Janaea Fine.
Yes, ma'am.
Ms. Fine, before we go forward with your sentencing, I'm gonna have you drug tested today to make sure you're clean, okay?
Okay.
Have a seat in the jury box. We'll get that done first. Michael Garrett, looks like I'm signing a dismissal of Mr. Garrett's case now. He's free to go.
Okay, thank you.
Yes, sir. I know.
Client of mine, Rodney Haynes, is one I just signed up, retained on. He was down in misdemeanor court, everything was taken into custody out of this court. They brought him over here. It looks like he had a drug patch that came back positive. So I don't know, is he setting up no bond as of now? How do you?
No, I usually set a bond. There's a bond set. When I raise it, I usually look at what the original bond was and raise it. Ms. Holmes could probably look at it.
Right.
No, maybe not. If you want to,
I don't want to look on.
yeah, yeah, you might want to just, if you want to file something, I'll take a look at it, but
Okay.
obviously it was Mr. Kelly on Dondre Blewett.
I just sent paperwork, Your Honor.
Is there paperwork on, are we doing both cases?
Yes.
Thank you. Good morning, sir. You're Dondre Blewett.
Yes, ma'am.
Morning, Mr. Kelly.
Morning.
Will your client waive the formal reading of the indictment and the motion?
Yes, we do.
And I wonder if, clearly we're pleading open, but we also don't really have an agreement on which violations of the motion we're gonna plead to. We're gonna plead to the
I'll go.
aggravated assault, obviously, with some of those that are.
I'll go through probably the whole thing since it's unagreed.
Thank you.
All right, Mr. Blewett, and cause number 26 DCCR 0362, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that's from February 1st of 2026. And how do you plead to that charge?
Guilty or not guilty? Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with? In that case, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kelly? Do you fully understand them? And it looks like there is no agreement, and so you have not waived your right to appeal, but you're leaving your punishment up to me. Is that your understanding?
Yes.
I want to make sure you understand you have an absolute right to have a jury come in and decide 2 things. The first would be to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right. And is that what you want to do? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection to number 1, Judge.
It's admitted. Is there any evidence that Mr. Blewett's not competent?
Not at all, Judge.
All right, then, and Mr. Blewett, in cause number 260362, find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. And then in cause number 22-41150, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation September 13th of 2023 for the offense of evading arrest or detention with the use of a vehicle, and that was an 8-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you committed the offense of aggravated assault with a deadly weapon on February 1st of 2026. And is that true or not true?
Yes, ma'am.
True or not true?
Sure.
Count 2 alleges that you were at a residence or at a location other than your residence at 12:32 a.m. on February 1st of 2026. And is that true or not true? Count 3 alleges that you committed the offense of harassment on February 1st of 2026. Is that true or not true?
Not sure.
Count 4 alleges that you failed to avoid injurious or vicious habits by brandishing a loaded firearm during the assault of Alondra Cantu on February 1st of 2026. Is that true or not true?
True.
Count 5 alleges the same thing really, but that you have failed to avoid injurious or vicious habits by brandishing that loaded firearm, and a child was also present, and that's on February 1st of 2026. Is that true or not true?
Right.
Count 6 alleges that you associated with a disreputable person, to wit Daniel Clark, or that you were at a location where a criminal act was being committed on February 1st of 2026. Is that true or not true?
Not sure.
Count 7 alleges that you failed to immediately report to the probation officer your arrest from February 1st of 2026. Is that true or not true? Count 8 alleges that you became intoxicated or were under the influence of an intoxicating substance February 1st of 2026 in violation of your probation order. Is that true or not true?
True.
Count 9 alleges that you possessed a firearm and ammunition in violation of your probation order, and that's from February 1st of 2026. Is that true or not true? And then count 10 alleges that's really the same as 8, so I'm gonna skip 10. All right, did you enter your pleas of true to counts 1, 2, 4, 5, 8, and 9 freely and voluntarily? And did you plead true to those counts because they're actually true?
Yes, ma'am.
I also have here on the tablet in that case some documents that have your signature on them, but the state's marked as exhibit number 1. Did you also go over these with Mr. Kelly before you signed them? And it looks.
And that brings us to the end of today's courtroom proceedings. We saw defendants receive second chances through probation, strict warnings about violating court orders, and attorneys being reminded that courtroom decisions come with real consequences. The judge made one message crystal clear: probation is an opportunity, not a free pass. Follow the rules, and you may walk away without a felony conviction, but violate those conditions, and the consequences can be life-changing. What do you think about the judge's approach in these cases? Was she being fair, or were the warnings too strict? Let us know your thoughts in the comments. And if you enjoyed this courtroom breakdown, make sure to like, subscribe, and turn on notifications for more real courtroom moments and legal analysis.